Members, the ayes are 61, the noes are 59. Schedule 4 as amended will stand part. We now come to the debate on clauses. The question is, are clauses 1 and 2 stand part? The Honourable Ruth Dyson.
Mr Chairman, I'm pleased to be able to take what's probably going to be the final call in the committee stages of this bill on title and commencement for me. I'm sure that other colleagues will want to make a contribution as well. The first query I want to raise, and I do hope that the Minister and the Chair is better able to answer the question that is addressed by members of the House than the other ministers who have been sitting in the chair, and that is in relation to the commencement date. This is actually a really unusual situation. The original provision was that any provision that has not earlier been brought into force comes into force on the day that is 2 years after the date on which this Act receives the royal assent. And I know the Honourable Maurice Williamson is very attentive to detail, and I would encourage him to take a call and tell me, has he ever heard of such a rigmarole of commencement as that? Any provision that has not earlier been brought into force comes into force on the day that is 2 years after the date on which this Act receives the royal assent. It's a bit of a challenge. The next bill that we're debating, the Plumbers, Gasfitters and Drain Layers Amendment Bill, fortunately has a much more straightforward commencement provision, which is sometime in the past. It may be equally contentious, but it's quite different. So the commencement provisions in this are very unusual, Mr Chairman, and I would really appreciate the Minister making a contribution in regard to that original proposed commencement date, and then why it was replaced on, again, a very complicated regime, which is the Act comes into force on the earlier of the following, either A, the date appointed by the Governor-General, not as is usual on the date of assent, but by order in council, or the day that is 2 years after the date on which the Act receives the royal assent. So, again, quite an unusual provision. So that's my first question to the Minister, and I strongly encourage him to take up the mandate of sitting in the chair and answer the question. He could answer the earlier question that I posed to Minister Adam in relation to proclamation, because that wasn't answered either, or he could answer the earlier question that I put to the Minister who's primarily responsible for this legislation, the Honourable Simon Bridges, in relation to any legal advice he received on the supplementary order paper that he dumped on the country on Easter Sunday. Simon Bridges didn't answer that question either. They're all important matters. It's the only opportunity we get in this House, and I frankly wonder why some of these ministers draw their salary. They sit in the chair, read the paper, fill out the crossword puzzle, or read some important briefing papers that are significant to the future of the country, but don't take up what should be their responsibility and answer questions from members in Parliament. If they're not up to the job, I consider that they swap with somebody who is. Honourable Maurice Williamson sitting there, and I've never known him resist an opportunity to make a contribution to a debate, even if he's obviously unaware of any detail in relation to the particular matter. It's never stopped him taking a call in this House before. Mr Chairman, I now want to refer to the title of this bill. This bill sounds pretty, won't do much harm. Crown Minerals, brackets, permitting and Crown Land, close brackets bill. Well, I think it overlooks one of the biggest concerns that we've had in this. The title doesn't refer to it at all, and it should. This is about the muzzling or bulldozing or sidelining of the Minister of Conservation in regard to significant matters of decision-making power, and it should be reflected in the title. It should be called something like the bulldozing of the Minister of Conservation. That wouldn't be far from the truth. It could refer to the outcome of this legislation, because what is going to happen is that our conservation values are going to be put aside, and the economic benefit test, where money is made for some company, not even necessarily based in New Zealand or contributing to the New Zealand tax system, that will win out over our conservation values, which we have held so dear as part of the New Zealand fabric of society for so long. So we could just call it money over values, because actually that's going to be the outcome. What is, I think, a bit of cheating of the New Zealand public is having a title of a bill that doesn't in any way refer to the outcome, which will be, as I said, those conservation values getting trampled over, the Minister having his or her throat squashed to the point that will just get a little squeak out of the Minister of Conservation, not a strong, clear advocacy voice as we've had in the past.
Mr. Chair.
I call Moana Maki.